A very good morning to our members, MIIM members and friends in Germany, and a very good afternoon to all our participants and speakers joining in from India. Thank you for joining us today for the webinar, India's Labor Law Reforms, Regulations for German Mittelstand Companies, organized under the MIIM program in association with our partner, RÖDL and Khaitan and Co. I am Mona Desai, your MIIM coordinator in Germany, and I have the pleasure of taking you through today's session. Before we continue, some technical aspects. In the upper right-hand corner of your screen, you will find the control panel. Here you can adjust the audio settings and choose between your headset or computer audio. A bit further down the dashboard, you will find the question panel. Here we request you to post your questions and we shall take them up in the final leg of the webinar during the Q&A session. For those who are joining us for the first time, allow me to briefly introduce the MIIM program to you. MIIM is an initiative of the Department of Promotion of Industry and Internal Trade and the Embassy of India in Berlin. It provides a platform that integrates a wide range of support services for German Mittelstand companies and family-owned enterprises. In today's webinar, our speakers will provide a perspective on the new labor laws recently announced last month and how changes can streamline operations and enhance your working operation in India. Without further delay, we shall commence today's webinar with our guest speaker from Schmalz India Private Limited, who, if I may say, is a long-standing MIIM partner and member. We have with us Ms. Mayura Kunachi. She is a human resource enthusiast, if I may say, and professional with over 15 years of experience managing both strategic and operational HR functions. Throughout her career, she has specialized in talent acquisition, employee engagement, performance management, and labor law compliance. Her professional journey began with Foresia Group, also known as Forvia, where she spent 8 years. This was followed by Growell Softec, and since 2018, she has been a proud member of the Schmalz family. Ladies and gentlemen, I'm very happy and very proud to present Ms. Konachi. Mayura, I now hand over the virtual mic to you.
Thank you. Thank you, Mona. Thank you all. So I'm really grateful to have an opportunity to introduce myself and my company on this platform. Talking about Schmalz India has begun its journey in 1999. We started with a rented office in Hyderabad and with a single employee along with 13 customers. In 2000, the company moved to Pune, starting the production of polymer products in Bhusri office. We are proud to inform you today we have two facilities which helps in production as well as the other facility where we are now taking care of handling system assembly and store. 5 years ago, Schmalz India had 130 plus employees, and today we have grown up 170 plus employees, serving to 4,200 customers with an average growth of 16% annually. Our turnover now stands at 100 crores approximately. In 2023, we installed solar power system, reinforcing our commitment to sustainability. To meet the rising demand and competitive landscape in India, we have localized most of our best-selling products. We have also started design services for Schmalz Germany, and now it's a very good moment to inform you, we have also evolved into AI-driven development support. In this year, we have launched a dedicated AI and digitalization department with focus on predictive maintenance, intelligent automation, and data analytics. The future vision is very clear. We would like to take the lead in the industry with the AI-powered innovation, digital platform, and sustainable practices, continuing our legacy of excellence and customer centricity. To add on to this, at Schmalz, I take pride in leading and implementing the people-centric HR initiative, like employee-friendly policies, promoting an open-door culture, establishing process-oriented approach, and driving diverse employee engagement activities. So when I talk about the employee engagement activities, we do different types of celebrations like festival celebrations, sports league, birthday celebration, and much more. This initiative ensure that employee can actually participate, collaborate, and enjoy a positive and vibrant work culture. Our biggest strength lies in our strong employee relation. This reflected in to about attrition rate. Our attrition rate is only just 3%, whereas if you talk about our service tenure, which is 10 years. Today, we are growing a team of over 170 employees, out of which 30% are women employees. Recently, we have also conducted one survey on workplace safety and POSH awareness. So it's given me a very proud moment to inform all of you. 100% of our women employees have mentioned that they are very happy and they feel safe, supported, and satisfied with the culture and the care provided by the company. As a HR professional, I firmly believe that when we prioritize employee development, well-being, and safety, we not only enhance the organizational effectiveness, but also foster deeper employee satisfaction, trust, and engagement. Over the years, I just learned HR is just not about the framing the policies and processes, but it is mainly about the people, culture, and creating an environment where everyone can thrive. With respect to our today's topic about the reformation of wage code, I would like to add on this point. Of course, I believe this new code will bring the uniformity, transparency, and stronger retirement benefit to our employees. Also, being a German company in Schmalz, we are already following a 40% basic pay structure, and we are also strongly complied. So I can see a very minimal disruption as the code mostly formalize the existing practices. But I also feel whereas the organization who is not aligned with the industry standard will definitely face a higher cost, salary restructuring, and the challenge to inform about the communication with the employees. So overall, while employees will gain the clarity, security, and the adjustment burden is heavier for the non-standardized employees. So this is I would like to mention about the new wage code. But before I conclude, I would like to express my gratitude to our Managing Director, Mr. Philip Money, because of whose continuous support, trust, and guidance, which has played a very crucial role in enabling me to drive people-focused HR initiative. So thank you all for your time. And I'm also excited to look forward to have today's experts' opinion and to understand more about the new wage code. Thank you. Thank you, Munaz.
Thank you. Thank you very much, Mayura. Thank you for sharing your expertise and all the good work that you and the team are doing in Schmalz. I would like to compliment you on your attrition rate. That itself speaks volumes on all the care that you and your team are doing towards your employees. And ladies and gentlemen, I want to also share that I've had the proud privilege of visiting this factory 3 to 4 times in my lifetime and career. And whatever she speaks, the team and the vibes always are very, very positive. And we are very grateful. Additionally, we want to thank you, Mayura, for partnering with us today in today's webinar, and very grateful to you and hope to continue to benefit from your presence going forward. So thank you very much to you and Philip. And now moving on, as you said, you are very keen, we are very keen, all of us are very keen. Uh, uh, it's a pleasure to introduce our first speaker, Mr. Vinay Joy, partner, employment, labor and benefits, and ethics and investigations at Khaitan and Company. Vinay is a partner at Khaitan with deep expertise on corporate law, employment law, and in conducting investigations. He regularly advises Indian and multinational clients on complex employment matters, including setting up documentation, business transfers, workforce integration, regulatory compliance, and internal relations. His unique blend of transactional and employment law expertise equips them to provide practical, business-focused insights. Pune is also part of the Khaitan's German desk, which offers dedicated cross-border legal support and seamless India-German advisory services for Mittelstand companies who are looking forward to invest or operate out of India. So without much delay, very keen to hear your address today. So thank you.
Thank you, Manas. Thank you for that. Uh, Good morning, good afternoon, everyone. Thank you for joining us today for this session. Obviously, a big watershed moment in Indian labor laws to have to sort of bring about this large exercise of consolidating 29 different laws into these 4 codes. Now, it's not something new. We have discussed this before. It's been in cold storage for the last many years now, for the last 5 years at least. And now it's finally come into force as of 21st of November. And in today's session, I'm going to take you through 2 of these codes, which would be the Code on Wages and the Industrial Relations Code. Apurva, my colleague at RÖDL, she will be taking on the remaining 2 codes right after this presentation. So maybe, what has been enforced? I think that's the key question. Firstly, as of 21st November, all the 4 codes were brought into force, barring a few very small administrative provisions. What that means is the framework for fixing minimum wages, payment of wages, bonus, all of that has been brought into force. The Provident Fund and the employee state insurance framework continues as is. There's no change there really. The benefits of gratuity, maternity benefit, all of that also still look to continue in the same form as they were, but with certain tweaks that we will talk about later on. There are new provisions for gig workers being workers who are outside the traditional employer-employee relationship, and used a lot by various platforms. So I think there are specific provisions covering those that have been brought about. The entirety of the Industrial Relations Code, which deals with trade unions, Industrial Disputes Act and Standing Orders Act, that has now been brought into force, and the entirety of the Occupational Safety and Health Code as well has been sort of brought in. So all of that has been enforced. Now, I'm going to talk about the Code on Wages firstly. What the Code on Wages does is it sort of assimilates all the laws relating to the concept of wages, their payment, what amounts to minimum wages. All the legislations around that have been consolidated into the Code on Wages. Now, what are wages? Now, it covers an intent to cover promised payments to an employee in return for the services that they render. And it does not look to cover what are called contingent payments or discretionary payments or performance-linked payments and reimbursements. All of that is usually been kept out under the purview of wages. Now, this next slide has a lot of text. This is actually the new definition of wages as per the labor codes. Wages very simply means all remuneration, whether by way of salaries, allowances, or otherwise, which is payable to an employee, and includes basic pay, dearness allowance, and retaining allowance. Why this is important is the definition has now been categorized as where previous definitions of wages across multiple other laws as well, they have always included what are wages and then sort of made some exclusions. So here the inclusions, if you read right from the beginning, it means all remuneration. So you have to keep that in mind. And then it goes into inclusions of basic pay, dearness allowance, retaining allowance. And then it gets down into a list of components which are typically going to be excluded from wages, which are things like your house rent allowance, conveyance allowance, any amounts that are paid to employees to defray special expenses. This would typically be in the context of, say, providing a uniform allowance or things like that. Things like commission, gratuity, bonus, all of those have been excluded from here. Now, there is what the twist in the new definition is this deeming provision, which has come at the end. What it says there is that if there are payments under each of these excluded components, which exceed 50% of all of the remuneration, then that amount above the 50% would be deemed as remuneration. Now, I know that's confusing language, and I'll just come to how that looks to operate. Effectively, what you need to remember is the exercise is meant to curtail employers from being able to keep basic wages low so that they can pile up on the other allowances, because a lot of contributions, social security contributions and other benefit contributions are usually made on the basis of basic wages and the other components that are generally included within the definition. So because of that, to prevent this anomaly of having a lot of excluded wages and having very few inclusions, the idea is to sort of balance them and keep them at 50-50. And maybe I will just get into showing you as an example as to what that means. Now, to put it very simply, you have to imagine these three circles where what is in blue is typically referred to as your CTC, cost to company, which a lot of you may be familiar with, which effectively talks about all the costs that you incur with respect to an employee. So that includes not only the employee's wages, it will also include these expressly excluded components like HRA, conveyance allowance, etc., that I just discussed. But then it would also cover other costs. Now, what are these other costs? These would be your employer contribution towards provident fund. It would be costs like gratuity. It would be if you're taking on certain insurance benefits that you're providing to employees and you're paying that premium on that. Now, all of those go into these other costs, which are, it's simply meant to be a number that you reflect to show that if I am to employ this employee A, then these are the overall costs that I incur. And that entire bucket is what is in blue, which is called your cost to company. Now, remuneration, which is the definition of wages that we talked about, is the wages itself, which is all the included components of basic pay, day earners allowance, and retaining allowance, and all your excluded components. So effectively, the combination of that, formulate what is remuneration for employees, and which is what will by and large be reflected on your pay slips that you give out to your employees. But what comes down to being wages, which is the small blue circle there, now that in case your expressly excluded components are over and above wages, then such portion of the expressly excluded components will be added back into the definition of wages so that they are equalized at 50-50. That's really what the new definition of wages provides for. Now, this is a working example of how that will look. If you look at the example here, there is a basic salary of 4,000 rupees. There's a day earners allowance of 2,000, medical allowance, and education allowance. Now, all of these constitute your wages per the definition of wages. And if you go back to the definition of wages, you'll see that medical allowance and education allowance are not expressly excluded components. And what that then means is, because the definition of wages starts off saying all remuneration payable, so they would get accounted for in the definition of wages. You then come to your excluded components, which are your HRA and your conveyance allowance in this example. And if you look at the math, it works out that the wages comprise 9,000 rupees, whereas the excluded components are forming 11,000 rupees, and which together collectively form the remuneration of 20,000 rupees. Now, for the purposes of calculating various benefits, your wage definition will not only account for the 9,000 rupees that it already is, but 1,000 rupees from this excluded bucket will get added to the 9,000 to sort of balance it at 10,000 each. And that 10,000 is what your contributions for, whether it's gratuity, PF, all of those contributions get sort of mapped out on the basis of that calculation. So that is an important change, because historically what has happened is that most contributions that have been made on the basis of specific definition of wages, which were different across various legislations. And now all of this gets codified into this one definition that will apply across all the 4 codes, which would cover all your social security contributions as well. So I hope I was able to make that clear. In terms of the other changes, in terms of minimum wages, the erstwhile regime under the old Minimum Wages Act used to provide that each state would sort of look to provide its own notifications as to what the minimum wages in that state would be. And of course, the Payment of Wages Act would then prescribe about timely payment of wages, what kind of deductions could be made, etc. Now, all of that gets subsumed within the wages code. So under the new regime, there is going to be what is called a national floor wage, which is going to be set out by the central government. And each state may also fix their minimum wages above that minimum national floor wage level that is set out by the central government. Now, frankly, we expect that the national floor wage, which will be set by the central government, will not be a very high amount, primarily because it will need to extend to the entire country, and because while cities like Pune, Bangalore, Mumbai, etc., will have a higher standard of living, other states may not be able to meet corresponding rates, and therefore we assume that the national floor wage will be a low wage threshold that will be set, and it will still continue to be the same format of states looking to fix individual minimum wages in each state. In terms of payment of wages, the compliances of having to make payment of wages to employees are not limited to employees who are earning 24,000 rupees per month. That used to be the threshold under the erstwhile Payment of Wages Act. That threshold is no longer there. So now it applies to all employees. You're required to have to pay their wages within 2 working days in case of their employment ceasing with you. And also on a monthly basis, by the 7th of the following month, you are required to have paid their wages. In terms of statutory bonus, most provisions with respect to the Payment of Bonus Act do not change. They continue to remain the same. There is a statutory threshold of 21,000 rupees to be able to receive bonus, which was there under the erstwhile Payment of Bonus Act. That threshold has not yet been notified under the new act, but right now things will continue at that statutory threshold level itself. So everything else remains the same. One new condition that has been added with respect to payment of bonus is that if you are convicted of an offense of sexual harassment, you might be disqualified from receiving statutory bonus. This is a new condition that has been added on, which is not there earlier. The other change is that earlier only male and female employees were required to be paid remuneration at the same level if they were performing the same kind of work. That flowed from the erstwhile Equal Remuneration Act. Now, transgender persons have also been included along with male and female employees for this requirement. So that's a new change again. Now, in terms of what is immediately the need of the hour, I think to the extent that companies have not already gotten their wage structures in place in terms of, I know a lot of companies undertook this assessment back in 2019, 2020 itself, when the code was first published. But to the extent you have not, it might be worthwhile taking a look at this. Mayura already talked about their practice of having basic at 40%, which is great. I think the idea should be to try and ensure that your components of wages now sort of reach at the 50% threshold so that contributions, etc., can be mapped out on that. And that will then take away any administrative troubles of having to apply this deeming fiction of pushing wages from one bucket to the other in case your salary structure has not been tweaked already. So I think that would really help. Again, there's no change really in the calculation or threshold of statutory bonus at this time. I think ensure that wages are paid by the 7th and within 2 days of cessation of service. Now, one common misconception that I'd like to clarify here is that a lot of people have been assuming that this 2 days period refers to when an employee gets terminated from service, you have to pay their full and final settlement of dues within that 2-day period. That is actually not the case. The requirement is to have to pay them wages, which would be the wages in that month up to that duration, and any past accrued wages. That will need to be paid out within 2 days of cessation of service, but other dues of their full and final settlement can follow the regular process as being part of your next payroll. For payments like gratuity, you anyway have 30 days to make that payment. So you can sort of look to follow that. I then move on to the Industrial Relations Code. Again, this code has been brought into force in full effect. It looks to subsume within itself the provisions of the erstwhile Industrial Disputes Act, the Trade Unions Act, and the Industrial Establishment Standing Orders Act. These are the 3 main legislations there. The key changes in this are with respect to computation of retrenchment compensation. It needs to be paid Earlier, it used to be paid as 15 days of average pay for every year of completed service. Now, while the formula remains the same, as we just discussed, because the definition of wages has changed, this component will get altered. In my experience, I think it's going to come down a little bit for workers, because earlier the definition of wages under the Industrial Disputes Act was used to include a lot more components than the 50% threshold that we'll be talking about going forward. So this is not necessarily a positive impact for employees in that sense. There is a new definition of worker which has been brought about in these codes. Worker sort of looks to replace the erstwhile definition of workman, which used to be there under the Industrial Disputes Act and a lot of our other industrial laws. Now, the main change in this definition is that earlier, any employees who were in supervisory capacity and earning more than 10,000 rupees per month, they were excluded from the definition of workman. That threshold has moved up from 10,000 to 18,000 rupees now. So that is important to bear in mind. I think the 10,000 rupees threshold was in any event hardly applicable to anyone who was going to be in a supervisory threshold. But now, maybe under this 18,000 new threshold, there might be some workers who might now slip into the definition of worker itself. So that will be something you can look to categorize your workforce in that fashion and to see who might sort of fall there or not. In terms of standing orders, again, standing orders were typically applicable to factories and plantations, etc. They were not necessarily applicable to commercial establishments. In most instances, a lot of states had given specific exemptions to them. But now, any establishment that has 300 or more workers is required to have standing orders in place and get them notified or certified. And so that will be a new requirement for even commercial establishments that have more than 300 workers. They will be required to sort of undertake this exercise, unless there are subsequent exemptions that are granted by individual state governments. Now, with respect to, these standing orders will need to be formulated in consultation with what are called negotiating union or a negotiating council or worker representatives. And that is something, the negotiating union is now going to be the union that has, most of the workers in your establishment. If they are signed up with a particular union, that will then become the negotiating union, primarily crossing the 51% threshold of your workers being members there. If there's no single union that has that kind of membership, then on a pro rata basis, the various unions within your organization will need to come together to form what is called a negotiating council. And depending on the the number of workers that they have, they will be able to nominate people onto this negotiating council, which will take on the role of being the union to negotiate matters with the establishment itself. So I think that is with respect to how that will play out with respect to trade unions. Now, one important change is with respect to the setting up of a grievance redressal committee. At this time, employers on the erstwhile regime had the flexibility to set up their own grievance redressal mechanism however they wanted. But now, under the new Industrial Relations Code, there are going to be specific provisions on how this committee needs to be formed. It needs to be a committee that has both employer and employee representatives. It's going to have a 2-year term. It can't be exceeding more than 10 members. The chairman will rotate between sometimes being an employer representative, sometimes being an employee representative. But those are large changes, and we will want to see how this gets implemented by companies going forward. But I think companies can hold on to this. Right now, nothing is required to be done because rules need to be notified for providing the mechanism for how grievance redressal mechanisms are meant to work, how the grievance redressal committee is meant to work. And so we'll have to sort of wait for that before sort of setting this up. Under the erstwhile regime, while government approval was required to terminate any employee or any workman if the establishment had more than 100 or more workmen, now that threshold has been increased to 300 workers, and therefore at least units which have up to 300 workers can now lay off or retrench workers more easily without having to go to the government for their prior approval, and that's a big change. There is a new concept of a worker reskilling fund. This is effectively a fund which is to be set up by the government, into which employers will be required to contribute up to 15 days of wages of a worker upon their termination or retrenchment. Now, the requirement is to have to make this contribution after the fund is set up. The fund is currently not set up. So in this intervening period, if there are any terminations or retrenchments taking place in your establishment, you don't need to make this contribution yet, or you don't even have to provide for a provision for that. You will only need to do it once that fund gets set up. Again, when it comes to recognition of trade unions, while under the erstwhile Trade Unions Act, people could come together to set up a trade union, there was no necessary mandate for an employer of an organization to recognize that union and then to look to deal with them, except in certain states like Maharashtra and Telangana, where regulations around that existed. Now, this concept of recognition of trade unions has been introduced under the new IR code. And so I think I already spoke about how a group of trade unions could become a negotiating union or council and get to collectively bargain with the employer. So that has been provided for. In terms of strikes and lockouts, under the earlier regime, only establishments in public utility services, that is your essential services like electricity, telecom, etc., workers in those areas, if they needed to go on strike, they needed to give prior advance notice. In other establishments, a strike could happen as and when it sort of came about. Now there is a restriction on conducting strikes and lockouts unless you have given an advance notice within 60 days prior to action, and a cooling off period of 14 days from the date of giving that notice. So this would apply to all establishments, which again, is more useful for employers, obviously, because they get to know when a strike is planned rather than a strike taking place instantly. And in terms of penalties, I think the erstwhile regime contained nominal penalties with a provision for imprisonment that ranged from 6 months to a year. Now, under the new code, there are heavier penalties that have been introduced, which are more monetary, and it's almost done away with all the imprisonment-related penalties under the IR code. Now, there's nothing very specific that establishments need to do with respect to the IR code immediately until the rules get notified. There is some ambiguity with respect to, until then, your existing standing orders should continue to operate, and you are required to sort of formulate new standing orders once the model standing orders, which are published under the rules, will get notified. So until then, you don't have to sort of jump to any actions. This only additional point to note was, again, I think by and large, the new regime for penalties across the 4 codes is that it's meant to be a facilitative regime. What that means is the provision for compounding has been brought in, which would mean that you can actually go up voluntarily to authorities to say that we have not complied with this, or we have missed out on complying with a certain provision, and they can let you go by charging you up to 50 to 75% of the maximum fine prescribed, rather than sort of going through elaborate penalty proceedings for that. Also, like I said, as is the case with the IR code, there's a decriminalization of most offenses under the codes generally, and of course with enhanced penalties to sort of try and make it more deterrent for employers to sort of not look to comply. I think that's an overall change. With that, I will stop. That is all that I had on these 2 codes. Happy to sort of rejoin at the end to sort of take on the Q&A as and when it comes up. I will sort of pass on the baton back to Monaz for now.
Yes. Thank you very much, Vinay. Thank you for joining us. Thank you for taking time out from your busy schedule. As we said, you are the India-Germany desk advisor, so you must be working at both time zones. But you for that very comprehensive as well as concise of the law with regard to wages and the industrial relation part. I know you wanted to cover much more, but given time constraint and our request, you have given us a compact picture. So we truly value that and appreciate that. And thank you for that insightful navigation also through that maze of those laws, and also giving those critical notes on how to stay on the right side of them as well. So a big thank you to you, Vinay, for joining us. And moving on, ladies and gentlemen, our next speaker is my esteemed colleague, Ms. Apurva Singh. Apurva Singh is an Indian lawyer and currently a principal associate at RÖDL India, where she leads the employment law practice. 7 years at the firm, and she advises a wide range of international clients, particularly the German Mittelstand companies, on Indian employment law, HR compliance, organizational structuring, and cross-border work matters. Her expertise range from employment law advisory, labor compliance audits, HR policy structuring, industrial relations, and workforce restructuring, as well as immigration and global mobility support. She regularly undertakes employment law due diligence and M&A transactions. Apurva is also building and organizational training. She conducts workshops on and workplace compliance and also focuses on anti-sexual harassment trainings under the POSH Act. Along with that, she customizes HR guideline sessions for global and Indian businesses. Without any further delay, we are very anxious to what you have to say, Apurva. So the stage is all yours.
Thank you very much, Manaz, for this introduction. So, first of all, a very good afternoon and morning to everyone who is present here. And it is absolutely my pleasure to join you today. Yes, as my colleague Vinay has already pointed out, yes, India has entered a historic phase of labor reform. As we know that with effect from 21st November, all the labor codes have been notified. Now, for today's session, I will be focusing on two of the labor codes that are directly relevant for the workforce protection and also carves out the employer's responsibility. The first being is, of course, the Code on Social Security 2020, which expands how workers also have access to the social protection across different categories of employment. As we saw in the previous session, that it's not only now restricted to the employees who are in a traditional employer-employee relationship, but it goes beyond, including even those who are self-employed as well, to get some social security benefit under this code. Now, the second part is, of course, the Occupational Safety, Health and Working Conditions Code, which consolidates almost workplace safety and welfare requirements into a more structured framework. So, from that perspective, it basically consolidates your all uh, establishment governing provisions, including the Factories Act, interstate migrant workers, contract labor regulations, all of them get consolidated into this one single code. So I would say that these two codes are central to the shift towards compliance 2.0, because they redefine now how organizations must also think about the workforce security, risk management and documentation, and also the operational preparedness. Let me pause here and highlight what are the four key messages that set context for the rest of the today's discussion. First, I would say that this reform is a step in the right direction. For decades, India's labor landscape was governed by multiple overlapping laws, even with a different, of course, with different definitions as well covered in, especially in the terms of the wages, which Mr. Joy already covered that, and some of them also dating back to 1940s. And what it was shown that the compliance for this was always often reactive, I would say, fragmented, and as well as documentation heavy. Now, with the new labor codes, the government signals, of course, a shift towards simplification, digitalization, and harmonization. And of course, this itself basically forms the foundation of compliance 2.0. Now, as you can see, instead of different thresholds, definition processes which are scattered throughout 29 central laws, all have them been now have been kind of consolidated to give a uniform meaning. Third, transparency and accountability, and of course has also significantly increased, which we saw. First of all, what we also saw that there is a higher penalty and accountability as well in case in case there are violations in terms of the provisions of these codes. And finally, the impact on the industry is both commercial and operational, because these labor codes now require a deeper review of how organizations manage people safety and compliance. So it's just not a policy or an update, like I said, but it basically it represents, or it is actually going towards a direction to have a wider shift, and also in having an overall compliance approach. So let us begin with the Code on Social Security. Now think of this as a digital reboot of India's social security framework. Now the Social Security Code represents a consolidated framework that brings together 9 different social security laws, which is ranging from Employee State Insurance Act to Employees Provident Fund Act, the Employment Exchange Compulsory Notification Vacancies Act, and so on and so forth. So these are the social security related labor laws. For decades, these laws have operated in silos, each with its own definition, threshold, and authorities and processes. So, at its core, the Social Security Code is designed with an aim to make it more inclusive, not only for the employees, like I said, who are in a traditional employer employee relationship, but it also goes beyond to include your gig workers, which we have already dealt with what constitutes platform workers, and even those to a certain extent who are self-employed, because even those who are falling from the self-employed, they generally fall under the unorganized sector, and depending on the central, when they notify the wages for those self-employed, they are also likely to be covered under this regime. Now, moving on, the code consolidates, first of all, it provides now for a single electronic registration under all these under all these laws which are covered under the Social Security Code. Important point to note is that establishments who are already having existing registration under the Employees Provident Fund Act, ESIC, those registrations will remain continued and valid. One of the key change, second major change also, which has been seen under the Employee State Insurance Act, where where the scope has been now extended. Now this ESIC, which was erstwhile was only applicable to limit, you could say that certain other districts were excluded, but we could say that now ESIC provisions now apply pan India all across. One of the key features which they have also introduced is that for the first time, employers can also take voluntary registration as well under the employee state insurance. And in case of hazardous sectors where even if one employee is there, still the ESIC provisions will apply. Now, moving on the point on taking the voluntary registration, the key point is to be remembered is that once the employer takes the voluntary registration as well under the same, then in this case, um, the opting out, there is a minimum locking period at least for 5 years before then the employers can opt out, of course subject to the majority of the consent of the covered employees. Similar as you know, under the employees provident fund as well, most of the provisions which are there in the existing have been retained. The voluntary option for enrollment has also been continued. Also, for however, under the employees provident fund as well, for the first time, employers also have the option to opt out as well in case of those who are not mandatorily subject to the same. For example, establishments with less than 20 or more employees, this is applicable for them. So in this case, of course, opting out again is permissible with subject to the minimum lock-in period of 5 years, and also subject to the majority of the consent of the employees. Now, benefits under the maternity provisions as well have been retained as it is, most of them, which is again 26 paid maternity leave to the women employees up to 2 children, of course. And a major change which we have seen is from the terms of the gratuity, as we are all aware that the fixed term employees are also are eligible to get the benefit under the gratuity. One thing that we have to keep it in mind is that the eligibility for fixed term for in order to be basically entitled for the gratuity payment, at least 1 year of service is mandatory. So this is something, there is and there is clarity about this, and there have been little bit debates also on this, but then this is what the position is. However, for all the permanent employees, the rule will remain the same, that the 5-year threshold will continue to apply. Also, as we saw, here the stricter of course enforcement is there for the non compliance as well, but however that we have seen that the authorities will indeed give a chance also to correct those measures, and in case the offenses which are also punishable with imprisonment as well, compounding option is also given. Now, let us turn to the second major code, which is relevant for the today's discussion, like Occupational Safety, Health and Working Conditions Code. This code, of course, brings together the 13 different legislations which are relating to the factories, contract labor, migrant workers, and also deals with the working hours and overall place safety. So I'll walk you through the major employer facing obligations and what are the operational shifts that we are looking at. So the first of all, the code applies widely to all establishments with 10 or more workers across, whether it's in manufacturing, IT, service sector. This significantly expands the reach of safety as well as the welfare standards that have to be, of course, observed for the establishment. Then there is also a coverage for the health and safety of the workers. It also introduces the common standards for the health, safety, and welfare across establishment, ensuring a baseline level of protection for all workers, regardless of industry. Mandatory electronic registration. It introduces about one unified registration under the same framework, where the registration, what we are looking at, is going to happen in the existing Shram Suvidha portal. But of course, further clarifications are also awaited from the government on this end. Pro-employment provisions, which we are going to see in the subsequent slides as well. One being that the occupational safety, health and working conditions code also emphasizes on formalization of the employment relationship. So which basically starts with also mandatory issuance of appointment letters to all the workers and employees. Now, let us see some of the key changes which have been, of course, introduced under the OSH code, which is the employer must first provide free annual health checkups for workers above 40 years of age. It is also, like I mentioned, compulsory to issue the appointment letters to all employees, workers, including contract workers. These duties basically signal a shift towards preventing health, of course, monitoring, and of course, having a clear documentation. Working hours and annual leave. Working hours to us have kept on the same level, in the sense we are talking about limiting to 8 hours a day. Then these changes basically streamline and also standardize the working hour provisions for all across. Contract labor, the special provisions also have been applied to the establishment in terms of the contract labor, that for the first time there has been a now clear prohibition on engaging contract labor in your core activities, subject to certain exceptions which are available. However, this restriction of does not apply if the establishment are taking some support services in the terms of the maintenance, cleaning services. Then of course, this restriction does not apply. Interstate migrant workers. Now, the definition has been a little bit modified to include workers up to 18,000 rupees to fall under this definition. Obligation is that there is an obligation of payment of journey allowances to every interstate worker to and fro from his native place and from the place of employment. Then the government is also likely to come up with a scheme also to conduct a third party audit by the experts, so that to facilitate the employers that they are matching the minimum requirements to be followed under the OSH code. Key important definition here is that now Across India, the revised definition of factory has been introduced, which now the threshold limit for factory has been expanded to 20 or more workers with aid of power, or 40 or more without the aid of the power. Then duties of the employees have also been introduced here. And so these are some of the key changes which are there under the OSH code. So I would say that overall, the OSH code, of course, moves towards having a more uniform, prevention-focused safety regime and making compliance more structured as well, and also more comprehensive. Now, without much ado, so that we have more time for the FAQs as well. Now, we have now come to the most actionable part of our session. With the codes being notified, of course, there are apprehension that what are the next steps, what are the immediate steps which the employers must take in order to align with the same. So first of all, immediate steps which we may have to take, but I would like to highlight that even though the codes have been notified from 21st November, there are, again, from the administrative point also, there are other certain clarifications which are still awaited from the central government on certain aspect. But as an immediate step, what industries and the employers can start doing so is at least start evaluating your existing compliance mechanism if there are any gaps in that. It starts from first your CTC's structuring to see the wage definition in order to first start assessing also the potential increased liability, as we saw that the definition of the wage has been revised to include even if it stays limit the 50% limit. So we may see a higher liability in terms of gratuity, cost, impact has to be assessed. Then next is, of course, the contract management. The OSH code has also tightened the rules around engaging the contract labor, especially in core activities. Now, every vendor and contractor with industries they are working, now it's essential that they are at least audited and also to assess their existing compliance practice if they are in order. On the digitization front, also we'll see now it is also the time to start implementing electronic registers, because this is what the codes also talk about, that it talk about maintaining now the statutory registers as well in the electronic form. A critical mind shift is required now, I would say. Now compliance is now a business enabler and not just a mere checkbox. This is something which we will have to take into account. And finally, a cross functional alignment. HR, human resources alone cannot do this. What we see here is that regulatory, finance, and operations have to come together as a strategic partners in this transition. Now, the goal is no longer piecemeal compliance, but integrated proactive risk management. So the message is quite simple now, that we start slowly, stay ahead, and build a resilient and compliant workplace for this future. Thank you for your time, and now I'm open for for the full floor for all the questions.
Thank you very much, Apurva, for those insightful statistics, parameters, and how to incorporate and understand these vital aspects of the revised codes. Thank you for also highlighting that all is not clear and that one needs to wait for further clarification and clearness in the matter. And as you said, without any further delay, we will dive in first. We've had an overwhelming response in both in terms of participation and questions. So Vinay, I would like to start with you first. Since Apurva has just had an address, and I think one of the final notes, she said that a lot of teams and financial departments also have to come together to support this new revision. So the first question is, what would be the financial impact due to the new codes?
Got it. Thanks, Manaz. See, I think there is going to be a change brought about by the change in the definition of wages. Like I said, erstwhile, individual contributions were calculated under specific laws using specific definitions of wages. Now, all of that has been made uniform. You have one definition of wages which will be used for calculating provident fund, gratuity, retrenchment compensation, maternity benefit, all of that. Now, the impact that it's going to have is going to be different for different contributions. For example, gratuity, something that Apurva said just before winding up, gratuity obligations are by and large likely to go up. Now, why that is the case? Because earlier you used to have only basic wages on the basis of which gratuity was calculated. And now you're going to have basic wages and anything else that formulates up to 50% of the remuneration. So there is a likelihood that gratuity payouts will definitely go up. At the same time, one impact will be for companies that have employees who are not, who are sort of have employees who are earning up to 15,000 rupees. Now, their calculation of provident fund for them, again, the formula on the basis of which provident fund will be calculated will have to undergo the same change. You'll have to apply the new definition of wages. And the likelihood is that the contribution might slightly go up. Given that, for employees earning up to 15,000, that impact is going to be there in terms of them taking slightly lesser home and contributing more towards PF. For anyone who's above that 15,000 threshold, by and large, the legal cap is there anyway on the maximum contribution to be made. So ideally, there should not be much of an impact on that. But other things like retrenchment compensation, again, in net numbers, it might come down a little bit, because earlier it used to be calculated on a larger portion of wages. Now it's going to be limited at 50%. So all of this, I think individual companies will need to look into their payroll practices. How is their cost to company structured for employees? And then look to try and rework this and then gauge the overall financial impact that it's going to have. I think the immediate impact, of course, is with respect to gratuity for employees who are going to be leaving between from 21st November until until, say, new rules come out or any clarification is put out by the government. You'll have to go by the new definition of wages in paying out gratuity, and that could be a higher payout for all of them. So that's an immediate impact there.
Thank you very much, Vinay. In the spirit of unity and diversity, what is always said about India, we have uniformity in diversity. If I may say so. Moving on, Apurva, first question to you. Under the new labor law codes, is there any ratio provided for employing employees in a fixed term to the permanent workmen, and how many times employer can renew the fixed term contract?
Thank you, Manaz. So yes, under the new labor codes, there is no such provision regarding basically the new labor codes neither provide any ratio for engaging the employees on a fixed term to permanent employees, nor there is a cap on renewal of such contract. So what we also need to keep in mind is that the benefits, whatever that has been extended to the permanent workforce, have to be always at par with the to the fixed term contract people and fixed term employees. So this is one of the key change.
Thank you. Next question is to you, Vinay. Are these labor codes applicable for the white collar workforce as well? That has something that has come up many times today. So I'm going to take one question on that because a lot of people have asked that.
Yeah. So I think one departure from the earlier regime was that under the earlier regime, all of your central industrial laws all talked about the concept of workman, which has been retained in the current framework of the labor codes as well as the definition of worker. But you also have the definition of what is an employee, which is a slightly wider definition. So the takeaway now is that these industrial laws apply not only to your workman category of workers, but also to your regular employees. Now, typically, people who are in management would in any event fall outside the purview of all of these laws, and they would be by and large driven by their contracts. But for everyone else now, these laws do tend to apply. And if you're depending on requirement might depend upon whether you fall as a worker or as an employee. But yes, most workers, I would say, leave aside your top string of management of the company and maybe one level below. but pretty much everyone else is going to be covered by these laws.
Yes, thank you. Thank you very much, Vinay. I can see the effort that you try to really keep your responses very brief and compact. You want to say more, but because of overtime, and that is where the next question lies, on overtime and whatever we are also going to exceed a little bit, 5-10 minutes, ladies and gentlemen, today. But because we are in the spirit of things, we will go ahead. So next question, Apurva, is on overtime. So what is the applicability of overtime for employees under the labor codes, and what clarity do the new codes provide? I think a majority of the people who have even not raised this question are interested in that answer.
Yes, thank you, Manaz. Yes, this is one of the question which we could see everywhere when once the labor codes were also first introduced, that whether all employees are also eligible for overtime. But Manaz, this is time and again. Uh, the position remains the same, which is right now under the existing law as well. That when it comes to giving overtime, it is extended to of course, those workers, of course, and employees who are drawing up to the minimum wages. So this is something, this overtime comes only from the threshold that who are basically drawing minimum wages as notified by the government, and they would be eligible if they are working beyond those hours. And this has now been also clarified in a better way in the codes as well. I think
we might have lost Monaz.
Yeah, there is a technical glitch.
No, I'm there. I'm there.
Okay, perfect.
Yes.
So,
but I'm there.
yes, so this is one
I'm
of
still
the
hanging in there.
clarification.
Yes.
So I'll tell you under the
yes.
codes as we know that employees across all sectors are going to get covered. So Central has anyway going to notify those scheduled employment as well, the employees, and also for respective, they're going to notify the minimum wage as well. So based on that, in relying on the minimum wage itself, then the overtime obligation will arise. But if you're talking about someone in a managerial position who is drawing a little bit higher, more salary on that, then the overtime provisions will not technically apply to certain extent.
Thank you. Thank you. Thank you for covering that. Thank you for covering that to the best of your capacity. And as you said, timeline, and as you said, spoke about the longevity. The next question, Vinay, is now coming back to the timeline. What is the phased implementation timeline for the 4 labor codes, and what specific compliance milestones should the German companies prepare for in 2025-26 to avoid, and we all know we don't like to hear this word, penalties?
Sure. See, I think what
but
one
we have
needs
to
to
deal
bear
with it.
Yes. So, see, I think what one needs to bear in mind is that all the 4 codes have been brought into force. Like I said, other than a few very small administrative provisions, the codes are in force, which also means that the erstwhile laws have been repealed. Now, what that means is that the substantive law that flows out of these codes is already in force. The rules are yet to be framed. That is, there are going to be central rules brought out under these codes, and then states are going to have to formulate their own rules to be able to enforce, these laws in each state. Now, I think the Labor Secretary had come out about a week ago saying that they're going to have the rules republished, and it's going to put it out for consultation for about 45 days, and then they're going to finalize those rules as well. So I think the timeline that the government is sort of looking to work at is latest by 1st of April 26 is when they intend to have these rules also formulated, and so then everything will then sort of get notified there and sort of implemented there. Right now, the point is, right now, the substantive law is in place, and you have to apply the erstwhile rules. In fact, the government notification that notified these 4 codes also talked about how during this transition phase, erstwhile laws will continue to apply, etc. So I think, if you ask me, what's going to happen is that I don't think authorities are going to clamp down on enforcement under the codes just yet. I think they are aware that there are a lot of ambiguities. There is a lot of uncertainty still around these codes and how they are meant to apply. And I think they know that employers are trying to grapple with these issues. So we don't expect them to take a hard stance against employers if there is not immediate compliance here. I do expect that once the rules get formulated, then yes, then they will look to implement these laws in their entirety. Even there, in my experience, typically when a new law comes out, by and large, enforcement at the get-go is a slightly, I would say it's more generous from the employers, from the authorities' side, that they don't look to penalize immediately. So I do think German companies and all other companies for that matter have time until April 1st at the very least to sort of get their house in order. If you've not started the process, I think that's something that you should get started on. Some of these important bits of restructuring your wages, like Apurva's presentation had, assessing your requirements for contract workers to see, how you use them, where it is implemented, what are your core activities. Now, all of that is going to be where I would say your activity should be, because, to be very frank, a lot of what is contained in these codes is actually a replica of what used to be there. I would say a lot of it is the same, and there is a bunch of new updates. Maybe 25% of it is new, but the remaining old 75% still exists. So it's not going to be as a world of change. Yes, then once the new rules come about, there might be new forms, new filings, new formats of things. But by and large, on a principle basis, a lot of it remains the same. So I don't think anyone has to panic right now. But I think it does make sense to get steps put in place to get working towards that.
Thank you. Thank you, Vinay. While these new regulations are going on, new colleagues also need to be onboarded at the same time. And with regard to that, moving to you, Apurva, a question is there that what new clauses does one need to include in the revised appointment letters after the implementation of the labor codes? So while Vinay tells us to wait patiently to apply them, what happens to the ones whose new processing letters are being?
Yeah. Thank you, Manas, for this question. So, like Vinay already said, that most of the provisions remain the same. And now, when it answering the question regarding what are the new clauses to be included in the appointment letter, we need to first understand that how structured our appointment letter is in terms of at least guaranteeing or recording the minimum, for example, the working hours which is at par, also having a clear transparency. Also we also saw the definition of the new wage structure. So CTC structure, we need to also understand that once we agreed, it also becomes a part of the contractual arrangement as well. So we have to be a little bit more careful as well in the appointment letter if we are also putting the right salary structure as well. But overall, especially in terms of night shift as well, because for women employees, we're supposed to take a written consent. So that is one of the crucial, that there has to be at least written documentation. So these are the different aspects which will have to be now updated in the line with the OSH code and other labor codes. And I would like to highlight most important as well, as we saw that it is mandatory as well now to issue appointment letters to all employees and the workers. And what we've seen that we still live in the situation where this documentation part may be missing. So for those companies who do not have that documentation in place, now is the time to at least start having the appointment letters, so and forth, policies at least in order.
Thank you. Thank you, Apurva. We are getting a tsunami of questions. I will have to really now pick and choose. Vinay, if you can answer the next question in a yes or no, if you can. The question to you is, Mr. Joy, could you please provide more details regarding the payment of full and final settlement within 2 days? Perhaps that you can take on separately. But does this mean the amount should be credited to the employee's account within 2 days? Would that be possible in a yes or no or a one sentence?
So I'd actually covered this as part of my presentation itself. What is required to be paid out within 2 days is wages. And if you look at the definition of wages, it doesn't include retrenchment compensation. It doesn't include other statutory dues. So what you're required to do is, let's say today you are letting an employee go as of 10th of December. By 12th of December, their wages for the 10 days should be credited to them, including any other past wages itself. But if it comes to their retrenchment compensation, gratuity, other dues, you have time to pay that. You can pay that as part of your normal course or your normal policies. There's no problem with that.
Thank you. Thank you. There is another one, whether variable pay is part of CTC to comply rules that basic salary should be 50% of CTC.
So that's an interesting one. Now, if you look at the definition of wages, it excludes any bonus provided under law, but it doesn't otherwise sort of talk about bonus as an exclusion. But that said, there are case laws to the point that a variable bonus by its very nature is variable. There is no guarantee that it's going to get paid out to you unless you have a practice of paying out, let's say, determining an upfront, a fixed bonus that, hey, you're going to get 5 lakhs of bonus at the end of the year, and we're going to start paying it out on a monthly basis. Now, in that situation, yes, it will get counted towards wages. But in any other circumstance, if that is dependent upon your performance, company's performance, various other aspects, then I would say no, that would not get counted as part of wages.
Thank you. There's another question also, which I think can be responded briefly, whether eligibility criteria for gratuity is revised from 5 years to 1 year.
So Apurva, you want to take that?
So yes. So then this is something which we have already covered, that for all permanent workers, the eligibility criteria remains the same, 5 years. This 1 year we are talking about only applies to these fixed term employment, and like I said, the whole objective behind this is that the fixed term employees also are not at the disadvantaged position, and this is what the central and the government also intends to achieve. So this 1 year pro rata basis is only for the fixed term employment. So for example, if a person has a contract period for 2 years, at the end of the tenure period, then that person would be eligible to get the gratuity on a pro rata basis. And we would also like to stress that other remaining provisions under the gratuity.
Thank you, Apurva. Ladies and gentlemen. Oh, sorry.
Yeah. Just the last part, we would also like to stress that the other provisions in the gratuity still remain the same regarding for permanent workers, that in case of death, the basically the period of 5 years is not necessary. All those provisions substantively remain the same.
Thank you, Apurva. I believe we'll have to call it a close just for the moment regarding the question and answer. This is a topic that will take the whole rest of the evening of yours and rest of our day here. But that doesn't mean this is the end of it. We would like the audience to engage with you all. You all have shared your contact details. I will be sharing the presentation. That has been 50% of the questions from already the tsunami of the questions, that the slides and the presentation will be shared with all of you. And with that, we want to thank our speakers for joining us today's webinar, from Mayura to Vinay to Apurva and dear attendees. Thank you for your patient listening and your support by being present all the way till the end. And a big shout out to my brilliant backend support team of Effie, Jessie, and Larissa for their constant support. And thank you for your continued partnership. And in advance, I would like to wish you all a Merry Christmas from our team to yours, and yours to a successful start to the new year. And